Welcome to Credit and Bankruptcy with Reed Allmand. Reclaim your power for financial independence. And now, your host, Reed Allmand.
Hello everyone, I'm Reed Allmand, and welcome to another episode of Credit and Bankruptcy, empowering people to make decisions about their financial situation to better their life. Thank you so much for joining us today. We have a great show planned for you. We're going to be talking about a very important topic for many people, and that's going to be evictions. So right now, during the COVID disaster, it's really affected the economy. It's affected a lot of consumers and a lot of people that are renting. And maybe they fall behind on their lease payments, their rental payments, and they're facing eviction. So what are your rights? And what kind of deadlines and defenses do you have under the CARES Act and maybe in your local counties and cities? So one of the things I wanted to bring everyone's attention to is what's going to be in our breaking news segment for today. And that breaking news is that on June 15th, the moratorium on evictions that was signed into place by Judge Jenkins in Dallas County expired. So that means that now landlords are eligible to go forward and file the notice of eviction and also start the process with a hearing to get someone evicted. In addition, the CARES Act, which was enacted in March, provided for a 120-day period in which landlords were not allowed to start the eviction process if they're receiving government assistance or involved with a government program. And so I'll show you how to find out if your landlord is part of that CARES Act provisions, but that provision also expires on July 25th. So as you can see, July may be a perfect storm for a lot of things expiring that have been giving protection to you as a tenant, and now you may be subject to the process of starting an eviction. One other thing that's important to keep in mind as breaking news for July is also that the unemployment benefits that were put into place by the CARES Act that provided for an additional $600 per month, or per week I should say, for people on unemployment is also set to expire at the end of July. So now I've got your attention and know that a lot of stuff is coming to the end in July. I want to tell you how you can make smart decisions and explore all of your opportunities that are available to you under the law. All right, so we're going to get started now and talk about the eviction process in Texas and what these deadlines are and how they affect you. All right, so to get started, give you a little bit of history. Back when this started in March, with the COVID business, the Texas Supreme Court put a moratorium on evictions for the entire state of Texas that ended on May 18th of 2020. Furthermore, we had the CARES Act, which I just discussed in the breaking news segment, had a 120-day moratorium, and then also Dallas County, for those living up here in the Metroplex, also put an additional moratorium that originally was in May, April, and extended to May, and then it was extended to June 15th, which has expired and won't be renewed for an additional month. All right? So let's talk about the first one, and let's talk about the CARES Act. And I've got a special guest in the studio today who's helping me run the show. His name is Matt Stoker, and he may be asking us a couple questions.
Yeah, Reed, happy to be here. Happy to be learning about this stuff, actually.
Great. Glad to have you.
And I do have a question right off the top. Does the CARES Act, did it apply to all landlords, or are there certain exceptions here?
Great question. There's only certain landlords that are subject to the provisions of the CARES Act. And the next thing you may be wondering, well, how do I know if my landlord is part of that? Well, if your landlord has any kind of assistance or participation with any kind of federal programs, such as Section 8, if they receive aid from the federal government, if they have a mortgage that's insured by the federal government, surprisingly, a lot of landlords in the Dallas-Fort Worth area are subject to the CARES Act provision. So there are a couple ways that you can find out if it applies to you. So number one, if you don't know, you may have to serve discovery on the landlord. And I'm going to talk to you in just a minute about how you can do that discovery process. And number two, there is a website that has the National Low Income Housing website. Let me say that one more time. So it's the National Low Income Housing website, has a table. So if you think your landlord may be under these provisions, we're going to want you to do that. So I mentioned discovery, and so there's a 4-step process on how you can serve discovery, and I want to go over that with you. Number one, discovery is a legal term in which you want to find out information from somebody that is in opposition to you. And so it's a way to solicit that information potentially through a court proceeding that requires the person on the other side to give you the information you need, okay? So the first step would be to write an interrogatory. And an interrogatory is a legal term for questions that you want answered by the opposition. And so you're going to want to ask your landlord some questions. And so I have a form letter that we can show you on the screen later, and also that I can have available on my website, which is allmandlaw.com. And it'll give you the steps and the questions that you need to ask from your landlord. Some of those questions would be, do you have any kind of mortgage-backed mortgage on your property that I'm leasing from you as a tenant? Do you participate in any Section 8 housing programs? Do you receive any kind of financing or financial assistance from the federal government? So we're trying to solicit the information to see if they are somebody who's required to follow the CARES Act. And as a reminder, why is this important? Because the CARES Act prevents the landlord from taking any kind of eviction proceeding against you until after the 120 days expires, which is going to be on July 25th, okay? So step 2 in the discovery process is you may file a motion for expedited discovery if your landlord files an eviction proceeding in the Justice of the Peace Court. And you're going to file that motion, and you're going to list those questions that you wanted answered from the landlord. You're going to ask for the Justice of the Peace to enter an order requiring the landlord to respond to those in an expedited manner. You're going to then serve that motion onto the landlord. And when I talk about serve, you're going to want to have some kind of verification or proof that it was delivered to the landlord. So one way you can do that is by certified mail. You can do hand delivery, you can do fax. My preference would be certified mail or fax, so that you're actually going to have some kind of verification receipt and acknowledgement that they received it. So once the landlord is served that, they're put on notice. And additionally, if the judge in the Justice of the Peace Court signs off an order requiring the landlord to respond, you're going to want to serve them a copy of that as well. This is all important groundwork that you're laying in case you have to actually go to a trial in Justice of the Peace Court. So this information now will require the landlord to send you those things where you can do your own research and determine, are they following the CARES Act program? And this process is something you would do before July 25th. So if your landlord posts you for eviction before July 25th, you're going to go through this process to make sure that they're in compliance and they can get after you early. Now, after July 25th, it's going to be a whole other story. We're going to touch on that a little bit later as well. So I hope everybody's staying with me. I know this can be riveting conversation, but I hope it's helpful for those of you that are out there. And for those of you who maybe know someone or have a loved one or friend, a college student, somebody else who's out there and you know that they're renting or leasing, and they've been affected by this COVID-19 situation because a lot of folks have been laid off. We have record unemployment, and the safety net and additional income that those folks have been receiving under the CARES Act for the $600 per month, that's also going to be winding up in July. And so we're seeing here as a bankruptcy professional, I can sort of see the storm clouds brewing and potentially setting the stage for August to be a month where a lot of these evictions are going to come to fruition. And so we don't want to let anybody get caught by surprise, especially any of your loved ones or friends. All right, so the second way that you can find out if the CARES Act applies to you, which I mentioned, was that low-income housing website. So we'll have that resource available on our website as well for you, so you can look into that. And so, Matt, you may be wondering, what about Dallas County? You know, you're here in Dallas County, right?
I am. And so, yeah, it's I guess it's a little confusing because the rules are different depending on where you are. So, yeah, I guess for those of us here in Dallas County, what do we need to know?
Right. You know, it's very interesting because we talked about a state provision under the Supreme Court. We talked about the CARES Act. Dallas County also put in additional provisions to help tenants as well. And so that was set in place by Judge Clay Jenkins. And many of you are probably familiar with his name who live in the Dallas County and Dallas City, because he is the judge that's been putting in all of the moratoriums on the closures related to COVID and requiring you to wear a mask and all these other things. So he originally enacted a moratorium that expired in April, and then he extended it to May, and then he extended it again to June 15th. And so after June 15th, he actually tweeted out some information that confirmed that he's not extending it again. So when that moratorium ended on June 15th, it's free game for landlords who are not covered by CARES Act to start the eviction process. And we're going to go through the eviction process here in a minute, so hang with me if you're interested to know how the eviction process works in Texas. So the other interesting thing, though, that he tweeted out is there was an additional provision that was enacted by the city of Dallas. And that provision requires that anyone who is considering going forward with an eviction is required to send a COVID notice to the tenant. And so this COVID notice, it explains in the order, has to require certain information and disclosures. But the spirit of it is to put the tenant on notice that you're behind. We're sending you this notice because our intention is that we're going to be requiring you to respond and let us know what's going on with you and what your plans are to take care of this lease delinquency and deficiency, or we're going to post you for eviction. And so that notice allows you as a tenant to get a 21-day response time period. And so his tweet was expressed, hey, look, just because it expired on June 15th, don't forget about this special provision to make sure your landlord is giving you this COVID notice, because the justice of the peace won't be checking on this provision, this requirement of the landlord. You're going to be responsible as a tenant to bring it up, okay? So if your landlord has previously sent you this notice and allowed you 21 days to respond, then after June 15th, if y'all have not worked out an agreement or you haven't taken this additional time to cure the lease delinquency, then they can go forward with eviction.
And so, I just want to say, I think it's nice that the city of Dallas has done that, because I definitely saw at the beginning of a lot of this stuff, there was a lot of misinformation going around, or maybe just hopes and dreams going around that, hey, I don't have to pay rent because of all this stuff. You know, this gets misconstrued, and, well, they can't evict me. That means I don't have to pay rent. So anything that you haven't paid yet is due. And so it's nice that Dallas is like, look, you need to at least remind these people, hey, you may not have been able to pay rent, but it is still due, and let's start to work this out before I just kick you out.
That's a really important comment. I'm glad that you brought that up, Matt, because that is a misconception that some people have. They think, you know, hey, the CARES Act has stopped them, the Dallas County stopped them. I got a free pass. This rent that I'm behind has been forgiven. Unfortunately, that's not true. The rent is not forgiven. It's just delayed. And so they're delaying the requirement for you to pay rent. It's actually not even delaying the requirement. It's delaying the enforcement. So all this is doing is delaying the landlords, to hold off the dogs. Don't sick the lawsuit on me. Don't sick the eviction notice on me. You can't evict me. As soon as this is lifted, which it's lifted now, at least under state law, and it's lifted under Dallas County, the only thing remaining out there until July 25th is the CARES Act. And then once that's lifted, it's free game. So be sure that if you have received the notice of eviction, you're going to want to check, once again, is my landlord covered under the CARES Act? And I'm going to tell you a little bit more information about that in just a second. Number two, is it the eviction started before June 15th? And if so, if it's a Dallas City eviction, did they give me the COVID notice that they're required to give me with a 21-day response time period? Okay. So I'm
curious now if everything has met all those standards, you know, all the dates have passed and everyone has gone through the process, then I assume we're just now dealing with a standard eviction. You know, I'm sure it's not standard for whoever's going through it, but what does that process look like if all of those things have been met?
Okay. So Texas is a very aggressive state as far as pursuing possession of the property, because that's what the landlord is after. If you're not paying for the property, they have carrying costs and expenses that they're looking to get taken care of, and they want the property back. They want to take possession back from you so they can get that property turned around and get another paying tenant in there. So let's talk about that. Let's talk about what are your rights under state law and what is the process to start that eviction. So to kick things off, as a tenant, the landlord is required to send you a 3-day notice to vacate. The 3-day notice to vacate happens when some type of default has happened under your lease agreement, or you may be a month-to-month tenant without a lease agreement. So that 3-day notice is going to be posted to your door or hand delivered to you, and it's going to say the landlord considers you to be in default. You've got 3 days to cure that default. If the default is not cured within that 3-day period, we're going to start the eviction proceeding in state court. Okay, so that's step one. Step two is, okay, that 3 days is expired. What next? So what they do is they file a notice of intent to evict you in state court. Now, there's a couple things they can do here. They can request attorney's fees and actually set it for trial, and give you additional notice period. Typically what they'll do is they'll just go ahead and not request attorney's fees from you. They're seeking past due rent, late charges, and possession of the property. And if they do that, they can get you set for an eviction hearing within 7 to 10 days of them filing with the court. So it's quick. We're talking a week and a half, 2 weeks tops. You're going to be before the justice of the peace. Okay? So what does that mean? When you've got the 6 to 10 day notice, you're going to be served a copy of that, typically by a constable. But they're not required to actually hand it to you in person and make sure that you got it and you know what's going on. They'll make an attempt, but if you're not home, they will post it to the door. And hopefully when you get home, it'll still be there. So I have heard from clients before who said, I didn't even know, I never got a copy of it. Unfortunately, that's not going to be a defense. Because the constable will say, I made an attempt and I left it there. And that's all that they're going to be required to prove. So remember, if you get the 3-day notice, you need to be on heightened spidey senses, all alert, wondering what's happened, get confirmation from your landlord if you try to cure that it's been cured. Otherwise, be on notice that you're probably posted for an eviction trial. So what do? Do you have to respond to that hearing? I would suggest that you go to the hearing, and if you have a defense to argue here, this would be when you would go into the process that I talked about earlier of the discovery. So if you're served the notice of intent to start the eviction process, you have a trial date set by the JP court. That's when you would send out that discovery request, file the expedited motion with the justice of the peace, asking the landlord to respond before the hearing date and verify and see if you have a defense based on the CARES Act. You might also have a defense based on the fact that you've already cured whatever default it was. You're going to want to need documentation and be able to prove that up with the landlord. Now there's a catch here. This whole process that I've been talking about with state and Dallas County and the CARES Act doesn't apply if the basis for the eviction by the landlord is because some type of illegal activity is happening in the property. If they're claiming that drugs are being sold there or there's some type of illegal activity going on, they're not restricted by any of these deadlines. They can immediately go to the Justice of the Peace Court and seek the eviction, okay? So what's left? So the final step here. Now you've been served the 3-day notice. The constable told you about the hearing happens. Typically you lose or you don't show up. Now what? So the judge will enter an order saying you've been evicted. And then the time period starts for you to file an appeal. You have 5 days from the date the judge signs the order evicting you. That includes Saturdays, that includes Sundays, that includes holidays. It's 5 days, period. If you do not file an appeal, then that becomes a final order, and then the landlord gets what's called a writ of possession. And so this is an order signed by the Justice of the Peace that says that the constable or the sheriff has the legal authority to forcefully remove you from the property. And we don't ever want to see it come to that. And you don't want to see it come to that, because that's when they will show up and order you to leave and physically remove you or physically remove your property. Okay? So that's the process for evictions in Texas. And like I told you when we started here, Texas is rough for tenants. I mean, it is heavily weighted in advantage for the landlord. This is not New York City where it can take months or years to get somebody evicted. You just saw here, I mean, this can happen in a couple weeks. From the time that the landlord wants you out to the time the landlord physically kicks you out, it can be 2 to 3 weeks. And so be cautious. Don't take the landlord's word for anything. If they've started a legal proceeding and they are filing things with the court, you need to be thinking, I need everything in writing. Because unfortunately, I've seen people before and talked with clients who have cured half of their lease deficiency. Let's say you're $5,000 behind and they gave the landlord $2,000, and the landlord led them to believe that if they gave them the $2,000, they were going to work with them. Well, they still go to the eviction hearing and say, okay, I got $2,000, but they're still $3,000 short, and still get evicted. And now you're out the $2,000 and you still have to figure out how to move. So if you're going to do any wheeling and dealing with the landlord once this eviction starts, get it in writing and protect your interest. Okay? So that's kind of horrible news there. You know, that's the problem with being in Texas. So what are your rights? What can happen to maybe flip the tables on your landlord? You might be asking that, wanted to know that, Matt.
Well, I mean, since the show is called Credit and Bankruptcy, I'm wondering, are there other remedies other than just, going to court or hoping to pay it? I mean, can you use bankruptcy to stall this process or perhaps turn it around?
You're right. Yes. Bankruptcy is a powerful tool that helps people stop evictions, and we use it in our office all the time. We help clients every single month, hundreds if not thousands of people a year. We help with this eviction process. And it really starts first with a getting to know you, your situation, and what are your goals. So I'll tell you the different availability in bankruptcy and what bankruptcy can do for you, but we also want to find what you want to do. Do you want to stay there? Do you want to try to cure the delinquency and finish out your lease? Are you done with the landlord and you're tired of their tactics and you just want to relocate, but you kind of need a little bit extra time, save up some money and be able to do that? We can help you do that too, okay? So what allows us to do that? When you file a bankruptcy, there's an automatic stay. And the automatic stay, a lot of people get confused about that. What is that? So it's a legal term and right that you have under the bankruptcy law, which is a federal law that tells creditors a bankruptcy has been filed, do not pass go, do not collect $100, do not go forward with the eviction hearing. If we get that bankruptcy case filed after you get the 3-day notice, but before the trial on the eviction, it's not going forward. It's stopped. That's when we need to see you. As soon as you get that 3-day notice, as soon as you're having trouble with your landlord, call our office at 214-265-0123, press line 1, schedule your free consultation with the attorney, find out what your rights are. I hate to see when tenants and clients have waited until they've already been evicted and then they call me up, because you just lost some of your options now and I might not be able to help you. So we want to get in there quick. So what happens if we file the eviction before the trial? So the advantage of that is that it's going to stop the eviction from going forward, and it's going to allow you then to decide, what do I want to do? Do I want to stay and pay, or do I want to leave and go and wipe out the debt? So let's talk about the first one. You're going to be able to have the option to assume or reject the lease. That's what we call stay or go. Okay. If you assume it, that means I'm agreeing to now be financially responsible for the lease agreement. I'm going to fulfill my end of the bargain, and the landlord has to fulfill his. And if I have another 2 years to go in this property, I want to take every advantage to keep that property. I don't want to move my kids out of the school district. We're already firmly rooted here. We like our neighbors. We don't want to go. Yes, we fell behind. We just need some help, and they're not willing to help us. Okay, so we'll assume the contract then, and then we'll talk to you about how we can help you cure that and stay in that property using a Chapter 13 bankruptcy. Flip side of that, you want to reject it. You're like, hey, I don't want to have to pay for this lease deficiency and this judgment. I want to reject this lease. I want to walk away debt-free. I'm not going to be evicted. I'm not going to have this on my credit. I'm going to go ahead and hurry up and just get my things together, move out on my terms, take advantage of the extra 30 to 60 days that I'm gaining by doing a Chapter 7 bankruptcy and split, okay? So let's talk about Chapter 13 and Chapter 7 and what is the difference. What do you think, Matt? What is your expectation about Chapter 7 and 13?
I'm going to be honest with you. I still am a little muddy on the differences between those bankruptcies in general. So I'm not sure how that would apply to an eviction. So maybe we could start there for me and go from there.
Okay, no problem. So a Chapter 7 is a liquidation. It's a process which you file the case, you list everybody that you owe money to, and you just want to wipe out that debt and you want to walk away debt-free, start your life over again. A Chapter 13, you also want to accomplish the same things that you're wanting to accomplish in a Chapter 7, but Chapter 13 is a payment plan. So it'll allow you to get a payment plan going with your landlord, catch up what you're behind, maybe restructure and refinance a car at a lower payment, lower interest rate. It can do a lot of things. It's a payment plan, so you got more flexibility to work around with stuff. So if you're wanting to keep your property, you do a 13.
Okay, so I have no option to... would I still be evicted then if I were to choose the Chapter 7 bankruptcy? I mean, is there no option to remedy that or in any way?
So the Chapter 7 is going to start that automatic stay provision. Typically, clients that do a Chapter 7, I advise that only if they're wanting to leave. Okay. But theoretically, you could file a Chapter 7 and you could catch up whatever you're behind and assume the contract, but you're going to have to do it quick. You're going to have to get it done really quickly, like within a few weeks to a month tops.
Okay.
So usually Chapter 7 is going to be those folks who are just wanting some extra time, and it gives you extra time because, like I said, the eviction is stopped in its tracks. And once you have the opportunity to file your statement of intention within a few days after your bankruptcy case, then that's when it puts the landlord back on notice that you're wanting to reject it. Then they have to get the bankruptcy protection removed, remove that automatic stay. Then they have to re-notice and start over the eviction process. That's why it gets you 30 to 60 or even longer, depending on how aggressive the landlord is, to get you back to in the same place that they had you before. But now you're in the driver's seat, you know it's coming, you got these weeks to plan, bank a couple paychecks, hire some movers, put first and last down somewhere, turn in the keys. You get that done before they get you evicted, then you can prevent that eviction, from going forward because you've already surrendered possession of the property back to the landlord. Okay. So that's in a nutshell how Chapter 7 works.
And then, so then with Chapter 13, you said that this was could set you up with a payment plan. Is that something that the landlord has to agree to, or is that something the court can say, look, this is a valid bankruptcy, and we're going to go through with it, and you have to play by our rules? How does that work from either perspective?
It's a little bit of both, and that's why you're hiring us, our law firm, Allmand Law Firm, to give you expert advice on how to deal with this. Because there is case law out there that says the do's and don'ts. What should you do if you're trying to cure this in bankruptcy? How should you set it up? How quickly do you have to pay back the landlord? What should you do afterwards? And so let me touch on some of those things. Number one, you're going to file the case. Under the Chapter 13, it stops eviction, and your first bankruptcy payment plan is not due until 30 days later. So the best way to kind of illustrate this is to give you an example. So let's say today is July the 3rd, and you are set for an eviction hearing on July the 5th. We file your case on the 3rd. We're going to take any delinquent lease payments or any kind of deficiency that you have all the way up through the day of filing. So that's going to include the July rent. Then your first bankruptcy payment is not going to be due until August the 5th, 30 days later. And your next lease payment coming due after you file the bankruptcy case is also not going to be due until August 1st. So then what you'll do is you'll start resuming your regular lease payment on August 1st as if you were never behind. And then you'll start up with the bankruptcy payment as well. And that bankruptcy payment is going to allow you to incrementally take care of what you were behind. So if you have 6 months left on your lease, you have 6 months to break up that deficiency. If you have a year, you got 12 payments to break that up. If you got 24, you got 24. So however much time is left on your lease, that's how much time you have to use a bankruptcy payment to catch it up.
Okay. I mean, that makes sense. I'm not sure, Reed, if you can answer this, but I am curious if from the other side, if I'm a landlord and I have a tenant going through a bankruptcy proceeding, however legitimate, and maybe I'm running a little lean, is there a remedy for me if I don't have money coming in from them to help, offset my mortgage or whatever it is I have to pay on that property?
Yes. So the landlord has provisions under the bankruptcy code where they can petition the bankruptcy court by filing what's called a motion for relief from the bankruptcy stay. Remember, we talked about the stay earlier. That's the power that stops them from going forward with eviction. So they can file this motion with the court and they can allege things like, for example, you're committing illegal activity there, therefore you should be able to be evicted. Number two, it's August 5th. You still haven't made your August rent payment that we talked about. You haven't made your bankruptcy payment. You're not doing what you said you were going to do under the bankruptcy plan. Therefore, you're out. Your Honor, please just sign the order. We're going to take them back to eviction court. We're going to get kicked out. So there are remedies and rights that are available to landlords to circumvent the bankruptcy protection and get you back under the state court jurisdiction to have the justice of the peace proceed, which is also why you've retained our firm, because we want to set you up and give you the advice and the direction and the plan. Now that's where we stop. Once we give you the plan and the direction, you're in the driver's seat. You have to follow that plan. And if you don't follow that plan, you potentially risk the landlord coming after you in bankruptcy court.
I got one more question for you, Reed, and I assume I know the answer to this, but I'm going to ask it anyway. I assume an eviction, I don't know if just the eviction process or if you are actually evicted, affects your credit. Is that correct? And how does that work?
Absolutely. If you are evicted, it does affect your credit. And so some people, filing a bankruptcy can also affect your credit. I've come across some people before who didn't reach out quickly enough to get the advice of a bankruptcy attorney because they were afraid of the negative impacts of the bankruptcy. Well, if you don't reach out and you don't file a bankruptcy to stop it, you're definitely probably going to be evicted. And that's a negative, and it's going to make it harder for you to find somewhere else to live. So if you know that that's going to be a negative, my advice would be, if you're a candidate and bankruptcy is helpful, file the bankruptcy case. Stop the eviction, either get your extra time or catch it up through the bankruptcy process. The added benefit is if you don't file for bankruptcy and you get evicted, you're also going to have a judgment for monetary damages owed to that landlord. And if you have a judgment in state court, then they can garnish your wages. They can accrue additional interest on that. That judgment can follow you for many, many years in the future. The bankruptcy wipes out all that negative information, all that financial obligation to your landlord. And we haven't even talked about all the other stuff bankruptcy does. If you have credit cards, if you have medical bills, if you have charge-offs, if you have late pays, it's also going to wipe out all of that debt too. So get a fresh, clean start, clear off all your bills, get your extra time, cure the lease arrears, and walk away from this situation in the best possible position that you could.
That sounds great. I appreciate it, Reed.
Okay. Well, let me give you my tip then and my suggestion. So this is my bankruptcy and credit tip for this episode. This is the best time right now for you to take action. If you've considered bankruptcy, if you are struggling financially, if you've had financial hardship related to COVID-19, you need to call us now. And this is why. This is why you should reach out and call us now. Number one, If your income has been reduced, you may be eligible for Chapter 7 bankruptcy. In order to be eligible for Chapter 7, you have to show a reduction in income or your income is below a certain threshold for eligibility. Well, if you've been laid off, you may qualify now for Chapter 7. If you wait until you're back employed and making higher wages, Chapter 7 may not be an option for you. So take advantage of this situation now and get that fresh start. Number 2, we're virtual. A lot of people aren't comfortable coming in, shaking hands, breathing on each other, wearing a mask. That's fine. We are set up to be 100% virtual. So if you want to talk to us, we'll have you assigned a secure portal through our website at allmandlaw.com. You can then log into that by just typing in your name and your email and password, and you can video conference with us right through the website on your smartphone, on your tablet, on your computer. If you don't want to see us or vice versa, we can do it by phone too. Typically, when somebody comes into our office to file a bankruptcy case, they have to see us 3 times in person. Once to retain us, once to return necessary documents, third and final time to sign everything. We can do all that virtually. And there's also a final added bonus, the cherry on top of the sundae, is that the bankruptcy courts by the U.S. trustee has also allowed clients who file bankruptcy to not have to appear in person. Typically, when you file bankruptcy, 30 to 60 days later, you have to go down to the Chapter 7 or the Chapter 13 trustee's office in person, get sworn in, and answer questions about your bankruptcy. Now that's also virtual for any cases filed through October of 2020. So that means that you can, from the comfort of your home, take advantage of filing bankruptcy now and never leave your home. So I hope that this information we provided you today is useful. I hope that if you are somebody who could benefit from our services, that you don't delay. Don't let shame or embarrassment stop you from reaching out and getting the information. The big corporations aren't waiting. They're filing for bankruptcy. You see it all the time in the news. So call us at 214-265-0123. Press option 1. We'll get you a time and an appointment that's convenient for you and your schedule to meet with one of our bankruptcy specialists. Thank you and have a great day.